Hello, welcome to the MOOCs program on corporate law. As a part of the MOOCs program in corporate law, this module is on the Insolvency and Bankruptcy Code 2016. I am Dr. Risham Garg. I am Assistant Professor of Law and also the Research Director of Center for Transnational Commercial Law at the National Law University, Delhi. As a part of this corporate law MOOCs course is a module on Insolvency and Bankruptcy Code. It deals with the insolvency, bankruptcy of corporate persons as well as natural persons. I will start by giving a brief overview about the module. The IBC 2016 aims to consolidate the laws relating to insolvency of companies and limited liability entities, including limited liability partnerships and other entities with limited liability. Unlimited liability partnerships and individuals presently contained in a number of legislations into a single legislation. Such consolidation will provide for a greater clarity in law and facilitate the application of consistent and coherent provisions to different stakeholders affected by business failure or inability to pay debt. Key objectives of an insolvency law. Although country approaches vary, there is broad agreement that effective and efficient insolvency regimes should aim to achieve the key objectives identified in a balanced manner. Whatever design is chosen for an insolvency law that will meet these key objectives, the insolvency law must be complementary to and compatible with the legal and social values of the society in which it is based and which it must ultimately sustain. Although insolvency law generally forms a distinctive regime, it ought not to produce results that are fundamentally in conflict with the premises upon which laws other than the insolvency law are based. Introduction. An effective insolvency regime is a critical component of ease of doing business in India. In India, the legal and institutional machinery for dealing with debt default has not been in line with global standards. The recovery action by creditors, either through the Contract Act or through special laws such as the Recovery of Debts Due to Banks and Financial Institutions Act 1993 and the Sarfashi Act 2002, has not seen desired outcomes. Similarly, action through the SICA and the winding up provisions of the Companies Act 1956 have neither been able to aid recovery for lenders nor aid restructuring of firms. Laws dealing with individual insolvency, the Presidency Towns Insolvency Act 1909 and the Provincial Insolvency Act 1920 are almost a century old. This has hampered the confidence of the lender. When lenders are unconfident, the debt access for borrowers is diminished. This reflects in the state of the credit markets in India. Secured credit by banks is the largest component of the credit market in India. Now, starting with the Insolvency and Bankruptcy Code 2016. The Insolvency and Bankruptcy Code 2016, hereinafter referred to as the Code, provides a comprehensive law to deal with insolvency and bankruptcy of corporate entities and natural persons. This discussion is divided in following sections. First, the salient features of the IBC 2016. Second, 4 pillars of institutional infrastructure. Third, corporate insolvency resolution process. And fourth, the liquidation process. The statement of objects of the IBC states that code has been enacted to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit and balance the interest of all stakeholders, including alteration in the order of priority of payment of government dues, and to establish an Insolvency and Bankruptcy Board of India and for matters connected therewith or incidental thereto. The salient features of the IBC 2016 are as follows. Clear, coherent and speedy process for early identification of financial distress and resolution of companies and limited liability entities of the underlying business is found to be viable. 2 distinct processes for resolution of individuals, namely fresh start and insolvency resolution. DRT and NCLT to act as adjudicating authority and deal with the cases related to insolvency, liquidation and bankruptcy process in respect of individuals and unlimited partnership firms and in respect of companies and limited liability entities respectively. Establishment of an Insolvency and Bankruptcy Board of India to exercise regulatory oversight over insolvency professionals, insolvency professional agencies and information utilities. Insolvency professionals would handle the commercial aspects of insolvency resolution process. Insolvency professional agencies will develop professional standards, code of ethics and be first level regulator for insolvency professionals, members leading to development of a competent industry for such professionals. Second, 4 pillars of institutional infrastructure. The 4 pillars of institutional infrastructure are insolvency professionals, information utilities, adjudication and the Insolvency and Bankruptcy Board of India. Now, insolvency professionals are the first pillar of institutional infrastructure. They are a class of regulated persons. They would play a key role in the efficient working of the bankruptcy process. They would be regulated by insolvency professional agencies. Information utilities are the second pillar of institutional infrastructure. These are required to store facts about lenders and terms of lending in electronic database. This would eliminate delays and disputes about facts when default does take place. Adjudication. The third pillar of institutional infrastructure is in adjudication. The NCLT will be the forum where firm insolvency will be heard and DRTs will be the forum where individual insolvencies will be heard. These institutions along with their appellate bodies with the NCLT and the DRTs will be adequately strengthened so as to achieve world-class functioning of the bankruptcy process. Adjudicator, the National Company Law Tribunal. The adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, is the National Company Law Tribunal, hereinafter referred to as the NCLT. The territorial jurisdiction of the NCLT will be over the place where the registered office of the corporate person is located. The NCLT before which a corporate insolvency resolution process or liquidation proceeding of a corporate debtor is pending will also have jurisdiction in the matter of the insolvency resolution or bankruptcy of personal guarantor of such corporate debtor. Civil court not to have jurisdiction. No civil court or authority has jurisdiction to entertain any suit or proceeding in respect of any matter on which NCLT or the NCLAT has jurisdiction under this code. No court, tribunal or authority shall grant an injunction in respect of any action taken or to be taken in pursuance of any power conferred on the NCLT or the NCLAT under the code. The Insolvency and Bankruptcy Board of India. The fourth pillar of institutional infrastructure is the regulator, the Insolvency and Bankruptcy Board of India, hereinafter referred to as the board, with head office in the National Capital Region and offices at other places in India. The central government has the power to designate a financial sector regulator to perform the functions till such board is constituted. Until the board is constituted or a financial sector regulator is designated under section 195, as the case may be, the powers and functions of the board or such designated financial sector regulator, including its power to make regulations, shall be exercised by the central government. Constitution of board of and the selection of members. There will be chairperson, 3 ex officio members from amongst the officers of the central government, not below the rank of joint secretary, and 1 ex officio member to be nominated by the Reserve Bank of India and 5 others to be nominated by the central government.